Welcome to Immigration Review, your weekly source for immigration case law updates and insights. I'm your host, Kevin A. Gregg, back again to review the week's precedential immigration cases, rummaging through the decisions so you don't have to. This podcast is sponsored by Kurzban, Tetzeli, and Pratt, also known as KKTP, a law firm where I'm also a partner. Whether you are facing an immigration obstacle, a serious injury, or a legal issue in your business, KKTP will aggressively protect your best interests. This podcast is also sponsored by Docketwise, an all-in-one immigration forms and case management solution trusted by thousands of immigration lawyers across the U.S. I really like Docketwise. It makes immigration applications easy by allowing the clients to provide information through simple online questionnaires that are shareable by text or email and available in multiple languages. Not only that, Docketwise provides a comprehensive group of case management features, including invoicing and calendaring, secure messaging, task management, and a lot more. You can learn all about Docketwise and receive a 10% discount on your subscription by heading to docketwise.com/immigration-review, so they know we sent you. And as always, this show does not constitute legal advice and has no bias other than to keep you up to date and to enable you, my dear colleagues, to excel in court. So, without further ado, let's start the review. In this special episode of the show, I speak with my fellow partner at KKTP, Ed Ramos, about petitions for review, petitions for certiorari, complicated matters of jurisdiction, and discretion. And we get pretty in-depth on two recent 11th Circuit decisions litigated by the KKTP firm, Patel v. U.S. Attorney General and Bordone v. DHS. Eddie's a bit of a veteran of the podcast. Some of you may remember that he appeared briefly way back on episode 11 to discuss his and the firm's 11th Circuit victory in Canale Media Holding LLC et al. v. USCIS. As I said back then, Eddie is one of the smartest and kindest people that I know, and at KKTP, he works primarily in federal district and circuit court litigation. We recorded our conversation on January 16th, 5 days before the inauguration. Lord only knows what's happened since. I hope you enjoy as much as I did. Hi, Eddie. How you doing?
I'm doing great, Kevin. Thanks for inviting me onto the podcast.
It is my honor. Before we get started, where are you?
So I'm in Japan. I'm in Sapporo, the great city like the beer.
And you live in Japan, right?
I do. Yeah.
So I'm just curious, does that make KKTP an international law firm?
I think it officially does. Where the sun never sets on the KKTP empire, as they say.
That's many people are saying that. Some great people are saying that. We're the colonial empire of immigration law.
Right. That's what Ira's known for, right?
I don't think he'll ever listen to this podcast, so really we can say whatever we want. So today you're going to talk to us about a lot of things, petition for reviews, maybe even cert petitions before the Supreme Court, and some interesting cases that you've recently been a part of that I find fascinating and incredibly complicated. Before we get started, what do you do for the firm?
So I'm mainly involved in the federal litigation side of what we do. So that's everything from district court cases in the appeals courts, and on some occasions, even up to the Supreme Court. And I also do some work with USCIS and the BIA in complex cases. And a good chunk of the work I do is in the EB-5 arena.
So a lot of the work is in the EB-5 arena. You just had an oral argument in the DC Circuit on the EB-5, right? Before we get to petitions for review, what was that about? Because I listened to oral argument and it was quite confusing.
It's a confusing case. Yeah, that case is it started out as a district court case, but the case is about challenging the government's policy of counting the spouses and children of investors against the worldwide limits. So I'm sure as all your listeners know, there's a limit to the number of visas that are made available in the EB-5 category, just like any other category for the preference categories. And the case is challenging this policy that's been a policy basically since at least 1965 of counting the derivative spouses and children. In this case, it's focused in on EB-5 investors. So if we win this case, then the spouses and children will no longer count against the worldwide limits, and it'll significantly reduce the backlog for the EB-5 category. It was my second oral argument, and it was definitely a challenging case to have as a second argument.
Well, I thought you did great. I listened to it on a plane flying back from Boston.
Thanks, Kevin.
So, Eddie, the first thing we were going to talk about is petitions for review. I was hoping that you could provide some tools and some just practical advice for immigration attorneys who are filing petition for reviews. It might be their first time, or even for seasoned petition for review filers.
Sure. So the first thing I would say is definitely encourage all lawyers that are involved in removal defense to consider adding petitions for review to sort of the profile of what they do. I think that's going to become increasingly important given what's happened to the administrative agencies over the past 4 years. Obviously the administration is changing. By the time your listeners are listening to this podcast, it probably will have changed, but the impact, as we all know, is not going to go away from what happened these past 4 years. And getting cases in front of Article 3 courts is an important tool. Petitions for review, doing it right is pretty time consuming. And there's a bit of a learning curve. If you're doing it for the first time, a lot of it, there's new procedures. You have to learn the mechanics of it. But there are definitely very good resources on those. And maybe, Kevin, you can include some of those in the notes to the podcast.
And so you're talking about pitfalls, and it ties into it. I think one of the biggest pitfalls for petitions for review is always jurisdiction, right, and administrative exhaustion as well.
Right.
And so related to that, I guess, just for individuals who've never filed a petition for review, why are we even talking about the circuit courts of appeals rather than the district courts?
Right. So the way that the review procedures are structured, if you're in removal proceedings and there's a final order of removal, you litigate the case in front of the immigration judge, you appeal to the BIA denies your appeal. The way it's structured is you have to go straight from the BIA to a circuit court of appeals, whatever the circuit court of appeals is that has jurisdiction over where the immigration removal proceedings were conducted. And that has to be filed within 30 days of the date that the BIA issues its final order. That framework was kind of designed to try to streamline the process. It used to be way back in the day, before 1961, these cases were filed in the district court. But since then, there's various jurisdictional provisions that channel everything up through directly to the circuit courts.
We use the phrase petition for review kind of to colloquially to refer to the whole thing, but really the petition for review in most circuits and all circuits it's usually like a one-page document, right? It's just kind of outlining what the challenge is, and that then initiates the process whereby the government then has usually 40 days to file the administrative record, at which point the petitioner, always the non-citizen, because the U.S. government actually cannot file a petition for review in circuit court from a BIA decision, then that starts the deadline for the petitioner, the non-citizen, to submit their opening brief, right?
You're exactly right. Usually that can be done electronically in at least all of the circuits that I'm aware of. And you have to make sure you file that one-page document plus the attachments that are required within 30 days of the date the BIA issues its final order. And then that kicks off a process where then the government files the administrative record, and then you file your opening brief based on that administrative record. And the little nuances are different in each circuit. Some circuits have a couple extra procedural requirements, but once you get the hang of it, the first time that sort of procedural aspect of it becomes sort of second nature.
I guess we could talk about petitions for review all day, but before we leave it, I've got two questions. The first is, what are just some weird things that you've encountered with petitions for review that you could advise practitioners against or to remind them to do? And then I'd like to get into jurisdiction a bit.
So I think one you, I think, touched on just a few minutes ago, which is exhaustion. And I guess this is sort of related to the jurisdictional issues that we're going to talk about. But one of the critical things that you have to be aware of when you're filing a petition for review is you have to make sure that any of the arguments that you're raising in that petition for review were arguments that were presented to the Board of Immigration Appeals and the immigration judge. In other words, they were what we call administratively exhausted. Because if those, with some very narrow exceptions, if those arguments were not exhausted, then you can't present them for the first time in the petition for review. Now, there's a whole complex area of law, regarding whether or not a claim was exhausted. There's some exceptions. For example, some due process claims don't need to be administratively exhausted. But the safest bet is just to keep that in mind. And I think that's actually a very good frame of mind to have when you're litigating a case before an immigration judge. Always keep in mind that ultimate goal of this case may end up being litigated on a petition for review. And so I have to think through all of the potential arguments that are in my case at the very beginning. And that, once you do some of these petitions for review, I think it actually helps to strengthen your whole outlook on the process, even from the very earliest stages.
Yeah, I mean, it's for that reason, for example, that I've been at least dropping a footnote before the immigration judge, advocating for the immigration judge to view withholding of removal cases under a lesser nexus standard, meaning that a protected ground need only be a reason to obtain withholding rather than one central reason for asylum, because there's a Ninth Circuit and a Sixth Circuit case that have set that standard for withholding cases, and that's contrary to a Board of Immigration Appeals decision, a matter of CTL, I believe. So while that argument really has no ability to succeed before an immigration judge outside the Ninth or the Sixth Circuit, or even the board, unless you're going to get the board to overturn itself, which is never going to happen.
Right.
You have to drop that footnote and argue it in order to get a circuit court to address it.
Right. Exactly. And it's better to try to throw out every possible argument, even if the IJ rolls his or her eyes at you. You need to get it out there so that you're preserving it for review, and you can even say it in court. If you're trying to raise an argument or an objection, and the immigration judge says, "Hey, come on, that it's contrary to BIA law, or I'm never going to buy that," or that the IJ simply is not going to bite on that particular argument, you still got to get it out there.
Yeah, the Seventh Circuit has been rejecting Pereira-based arguments simply because it's saying that the statute existed before the Supreme Court ruled in Pereira v. Sessions, and advocates should have been bringing that, even though I believe there was a published Board of Immigration Appeals decision at the time that said no. So from exhaustion to its ugly step-cousin, jurisdiction. What's going on with jurisdiction? Why is it such a big deal? And why is it such a hurdle in circuit court litigation?
Right. So I think immigration is maybe not unique, but it's certainly among the few areas of law where there's just so many jurisdictional hurdles to obtaining review. If you take a step back and you kind of look at the law generally, there's a strong presumption of judicial review. And in most areas of law, there aren't these jurisdictional issues that immigration practitioners encounter. But in the immigration area, there are a number of statutes that Congress has passed to limit the types of claims that can be reviewed through a petition for review. And the two main ones are, there's a set of what we call the discretionary decision bars that bar review of certain exercises of discretion or issues related to discretionary forms of relief. And then the other most common bar is it's called the criminal alien bar, that bars review for people that have certain criminal convictions. The one I think we were planning to focus on today is the discretionary decision bar, because that ties into this case, the Patel case that we were going to talk about.
Yes, the Patel case. The case where our firm represented Mr. Patel before the 11th Circuit when the 11th Circuit went en banc and got an adverse decision. The Patel case was discussed on the podcast in late August of 2020. And it's all about jurisdiction, right? And before we get into it, I believe you might have something to say about Patel that only happened yesterday.
Right. Yes, we filed our petition for writ of certiorari with the Supreme Court on the 15th. And so that case hopefully will be going up to the Supreme Court. We'll find out, I suppose, in a couple of months whether the Supreme Court grants review. But we're hopeful that we can get this bad decision reversed.
I know that wasn't your first time having your name on something submitted to the Supreme Court. I know you and I tried to get a stay of removal for that Yemeni individual about a couple of years ago that crashed and burned. But what did it feel? What did Justice Roberts was having none of that? But
right.
What's it like to file something in the Supreme Court? What's it feel like? I know we had the assistance of Wilmer Hale in this case.
Well, Kevin, it's a pretty heady experience. It's exciting to be involved in a big case like this, and certainly in a case that we're hopeful that there's a good chance review will be granted. But it's also definitely a lot of work. So
right.
Lots of sleepless nights.
What's going on in Patel? Why do you think there's a good chance the Supreme Court will take up the issue? And why is it so complicated?
The jurisdictional issue in Patel really centers on one aspect of the discretionary decision bar, or one subsection of the discretionary decision bar. So the site, if people want to take a look at this provision, it's INA 242 A2BI, little I. And this is a provision that bars review of certain judgments concerning 5 different types of discretionary relief. So it's adjustment of status, cancellation, voluntary departure, and waivers under 212H and 212I. So that's certain criminal waivers for certain criminal grounds of removal and of inadmissibility, and also the fraud inadmissibility waiver. And the key question here is, what is barred by this particular provision? So to tee up the question, and this is completely familiar to immigration practitioners, it's second nature basically. There are 2 stages to any application for discretionary relief. You have the first to show that the person is actually eligible for the relief. So for example, in a cancellation case, you have to show the physical presence. And then once you've shown that you've satisfied all of those threshold eligibility requirements, then even if you satisfy all of them, the immigration judge can still deny you relief as an exercise of discretion.
And getting out of the 10,000 foot level, I mean, it just is the fact that every single form of relief at immigration law is discretionary, except withholding of removal under the Act, and then Convention Against Torture Protection, which isn't even relief, it's a regulatory protection. But all the other things that can lead to a green card under immigration law are discretionary, right?
Right. And so the question in Patel was, you have these 5 specific forms of relief that are covered by this provision. And so the question is, what is barred? Is review barred of discretionary aspects of those decisions, or is review barred of everything? So to take the example of that actually was the Patel case itself, this was an application for adjustment of status, and one of the threshold eligibility requirements for adjustment of status is to show that you're admissible. If you're not admissible, then the government will move to pre-dermit your adjustment application. And if the IJ agrees that you're not admissible, you're subject to some inadmissibility ground, then you're never going to get to that discretionary relief step. And so in Mr. Patel's case, the government moved to pre-dermit his adjustment application on the ground that he had falsely claimed U.S. citizenship.
And that's one of the grounds that doesn't even have a waiver. Some inadmissibility provisions, you can at least apply for a waiver, but there is no waiver for false claims to citizenship. So that would tank Mr. Patel's adjustment of status application forever.
Right. Exactly. And so they moved to pre-dermit. The IJ agreed that that he had made a false claim to U.S. citizenship, even though Mr. Patel had testified that this was in the context of a driver's license application. And he checked a box on the application that said U.S. citizen. He in fact was eligible for a driver's license at the time. He had a pending adjustment application, and so he was eligible as a pending adjustment applicant for a driver's license. But he mistakenly checked the U.S. citizen box. That was his testimony. But the IJ ultimately rejected that testimony and concluded that he had intentionally claimed U.S. citizenship and therefore was subject to the inadmissibility ground for false claims to citizenship. And so when the case made it all the way up to the 11th Circuit, the jurisdictional question in the 11th Circuit was, can the 11th Circuit review that claim that he was not subject to the inadmissibility ground?
Right. And so one of the arguments that we made and that a lot of circuits have held is that that first question of inadmissibility is not really part of the discretionary relief analysis. That's an initial question that's not covered by the jurisdictional bar, right?
Exactly. And so, as you said, Kevin, the majority position across the circuits, in every circuit except for the 4th and possibly the 7th and now the 11th, in every other circuit, the law is that there is review, even for those 5 forms of relief that we talked about that are covered by this provision. You still get review over those threshold eligibility determinations that are not discretionary. So, for example, in Mr. Patel's case, whether he was admissible to the United States, that's not a discretionary determination. He's either admissible or he's not admissible. There's no discretionary element to that decision. And so there is review over that in most circuits.
Right.
Just to provide another example, in the cancellation of removal context, whether you meet the physical presence requirement. You either have been physically present for the requisite period or you haven't been. And so in most circuits, that issue is reviewable. If there's a factual dispute over that, and the IJ rules against you, and the BIA affirms, then you get review of that factual issue in the Court of Appeals.
Right. And in this case, the Patel court, the panel, really didn't give much thought to the jurisdiction bar issue. It kind of said we can't review whether or not he had the intent to make a false claim to citizenship because we're jurisdictionally precluded. And the 11th Circuit went en banc sua sponte on its own because clearly there's a big fight on the 11th Circuit about this issue. The judges who went en banc, I suppose, thought that they had the numbers to change the panel's decision in that regard, but what they got was the opposite.
That's exactly right. That was honestly a sea change. There was one other circuit without any reasoning at all that had adopted that position, the 4th Circuit. The 11th Circuit was the first circuit to really kind of go in depth and try to justify that interpretation of the statute. And as you say, Kevin, it's a sweeping interpretation because what it does is it bars review of any aspect of those 5 forms of relief, including threshold eligibility requirements. Now, I do want to throw in a little caveat here. It's an important caveat, which is there is still review in the courts of appeals for legal and constitutional claims because there is a savings clause. In 2005, Congress added in a savings clause, 242A2D, that preserves review in petitions for review for legal and constitutional claims. So if you have a legal or a constitutional claim, then you can still get judicial review, even for either the threshold eligibility requirements or any aspect of those forms of discretionary relief. But if you're raising a factual challenge, like an intent challenge, did Mr. Patel intend to claim citizenship? That's a factual question. You don't get review over those under the 11th Circuit's reading.
And just to be a cynic, Congress only threw us a bone at 242A2D because Justice Stevens said they had to in St. Cyr, right?
That's exactly right.
So just everything you want in immigration needs to be just earned through litigation, it seems.
Right.
Thanks, Eddie. Before we get off Patel, because this is a pet issue of mine, the Patel case itself is really about false claims to citizenship. At least the panel decision is really about false claims of citizenship and matter of Richmond. And matter of Richmond is a 2016 Board of Immigration Appeals decision in which the board held that in order to sustain a false claim to citizenship is a 2-pronged inquiry. 1, did the non-citizen have the subjective intent to obtain a benefit under federal or state law or under the Immigration Act? And 2, was the false claim to citizenship material to that benefit? And without this 2-pronged test, again, like we said, there is no waiver to false claims. So it is very important to have the proper legal analysis before you bar a non-citizen forever from immigration benefits. In the Patel panel, the 11th Circuit said that matter of Richmond's second prong, materiality, actually has no basis in the statute whatsoever. So they overturned matter of Richmond because they held that it unambiguously lacks a materiality component. And they threw some serious shade on the subjective intent in a footnote as well, but that was just dicta. And so in all other circuits, matter of Richmond remains good law, but in the 11th Circuit, as of right now, there is no materiality component because I believe it's actually the very last sentence of a 50-page Patel en banc decision. The en banc court says, by the way, we don't disturb the materiality analysis either. So what's the status of all of that at the Supreme Court? Are we challenging that as well, or are we just really going in on jurisdiction?
Well, we are. You're absolutely right. There are two issues in Patel. The main one is the jurisdictional issue that we've spent most of our time today talking about. But there is this second issue about materiality. And to tie it back into the jurisdictional discussion a bit, this is an issue that is a question of law. So the 11th Circuit did reach the merits of that question. And as you framed it nicely, Kevin, the question is there a materiality component? So what that means sort of in layman's speak is if someone makes a claim to citizenship that has absolutely no bearing on anything. So like, let's just say, for example, that you have, an application for a loan, an SBA loan. So it's a government benefit, but your citizenship has nothing to do with whether you get the loan or not. A materiality limitation would prevent that inadmissibility ground from kicking in if you can show that it wouldn't have mattered one way or the other. That's a very important limitation. And the 11th Circuit on the merits, as you say, reached that question and said there is no materiality element. We are including that as a second question in the petition that we filed one day ago. And we think there is a very strong argument that the 11th Circuit was wrong on that point. That the statute uses a term, false representation, that it carries with it a common law meaning. It's a common law term and it carries with it a materiality element. And the 11th Circuit never really grappled with that point. And it's actually a point that even matter of Richmond doesn't really grapple with, or in the other circuit court decisions. But there is strong Supreme Court precedent saying that if Congress uses a term that has a meaning at common law, that it brings with it those elements that were traditionally understood to be part of that term at common law. And materiality is one of them.
Hopefully we can convince some justices.
That's the hope. Just as a small practice pointer for people in the 11th Circuit, if you think that your case is affected by Patel, again, this goes back to this issue of preserving arguments. You're going to want to make arguments before the IJ and the BIA that matter of Richmond, the materiality requirement is still a component, even though the 11th Circuit ruled otherwise. And you can certainly cite to the fact that a cert petition has been filed, and then if the Supreme Court grants review to wait until the Supreme Court issues a ruling on that. But you're going to want to preserve that argument. And then on the jurisdictional issue too, if people have petitions for review in the 11th Circuit, the mandate was stayed in Patel. Now that there's a complex question about whether that actually affects the validity of that decision in terms of circuit precedent. It probably does. But you can certainly ask the government to agree to stay your case pending a decision from the Supreme Court on the jurisdictional issue. And that's probably smart as a strategic move. If you can do that before even the briefing is needed, then you'll know what to focus on in the briefing.
Before we go to Bourdon, I just want to mention, I believe this might be the wonkiest conversation in the history of podcasts, and certainly immigration podcasts, just the two of us talking about Supreme Court jurisdiction. If anyone is still listening, I really appreciate it, especially you, Grandma Lois. And so before we move on to the last segment of the episode, are there any practice pointers, any other tips that you want to say about Patel?
Sure. This is, I think, is something that is broader than just the 11th Circuit. But I think practitioners that are doing petitions for review that are affected by either the discretionary decision bars or the criminal bar, really look into that A2D savings clause, because many times issues can be framed in a way that presents them as a legal claim. So, for example, we talked about this, that the materiality question was a legal question. But decision from last term in the Supreme Court, Guerrero Lasprilla v. Barr. In that decision, the Supreme Court held that 242A2D, that savings clause, it applies not only to pure questions of law, but also to mixed questions of law. So in other words, if you have an undisputed set of facts, does that set of facts meet a particular legal standard? And that was held to be included under the savings clause. And so if there's a way to frame the claim as either the Board of Immigration Appeals or the immigration judge making a legal error, so for example, applying the wrong legal standard, or even announcing the right legal standard, but getting the law wrong and misapplying that legal standard based on the undisputed facts of the case, then those types of claims should now be reviewable. So try to frame your claims in a way that brings them underneath that savings clause.
It's good to remember. So the last case we were going to talk about is Bordone v. DHS, another 11th Circuit decision in which the 11th Circuit issued its decision in the case, I believe, over the summer. And again, this is another one of our cases, and we requested that the court go en banc on the case, and the 11th Circuit decided not to go en banc on December 23rd, 2020, but with a pretty strong dissent from Judges Martin, Jordan, and Jill Pryor. What's going on with Bordone, and why is it important?
Right. So Bordone, if it's possible, is probably even wonkier than the Patel case.
I can't wait.
So this is an even, as you said, less frequently encountered provision, the Adam Walsh Act. And so the Adam Walsh Act, it did a bunch of things in terms of, it was I think, a 60 or 65-page law. But the provision that's relevant to immigration law is it created a new, well, for the first time, it made certain U.S. citizens ineligible to petition for their family members. And so what it did is, if you have certain what are called specified offenses against a minor, mainly sex offenses against a minor, you're not eligible to petition for any immediate relative. So not only are you not allowed to petition for children, you're also not allowed to petition for spouses and parents. The I-130 petition will be denied, essentially.
And I think it's important to talk about it level-headed. I mean, first of all, the law is the law. This is what Congress wanted. But, superficially, it does seem like a very agreeable provision. That is, individuals who have committed sex offenses should not be able to maybe bring their family members to the United States or bring, say, young children from abroad, because there is a danger that the petitioner could be bringing individuals to the United States to abuse them. However, the Adam Walsh Act, as with the case of Mr. Bordone himself, is very expansive and can be applied to prevent any sex offender. It can be used to prevent them from bringing any family member, including, say, a 60-year-old wife or a 60-year-old husband,
right?
Which doesn't really necessarily have anything to do with the danger that someone who, for example, has been caught looking at underage pornography, it doesn't really jibe to me that individual is then a danger to a 60-year-old wife.
Right.
Is that? I mean, I know these are policy arguments, and Congress obviously grappled with them and fell on the side of being overly expansive. But that is what's going on here, and that is the extreme to which the Adam Walsh Act is sometimes applied, right?
No, that's exactly right. And on the policy debate, I think this is one of those areas where the law on its face, if you look at it superficially, as you said, Kevin, makes a lot of sense. But then when you look at it in terms of individual applications, it starts looking a lot less sensible. If as you said, if someone has been convicted of child pornography, do you really want to prevent them from being with their adult spouse?
In fact, it might have the opposite result in that instance.
Right, exactly. And so the jurisdictional provision, the critical aspect of it is there is an exception for people if they can demonstrate that they pose no risk to the beneficiary of the petition. But the tricky part is that the statute makes that determination, it entrusts it to the sole and unreviewable discretion of the DHS secretary, effectively USCIS, because USCIS is the agency that adjudicates these I-130s. And so the question that this poses, it's another bar on discretion. And the critical question in Bordone was, well, what happens if the agency violates the law when it adjudicates a petition. And what do I mean by that? So there's regulations, USCIS regulations, that say that all USCIS officers are required to follow binding precedent. One of the binding precedent decisions, called matter of choice, it sets preponderance of the evidence as the standard of review in all immigration cases, unless otherwise specified by law. And the Adam Walsh Act doesn't say anything about what standard of review the adjudicator should apply to make that no-risk decision. In a policy memo, USCIS said, well, we're going to apply beyond a reasonable doubt. You're not going to get your I-130 approved unless you show that you pose no risk beyond any reasonable doubt. And of course, that's the standard that's used in criminal cases.
It's the highest standard you can have under the law, pretty much.
Exactly. And so by applying that standard, the agency was violating the regulation that requires them to follow precedent decisions, because the precedent decisions required them to use the preponderance standard to make that no-risk decision. And yet they're using the beyond a reasonable doubt standard. And so the question, as we framed it, was, if the agency violates its own binding regulations, is that a discretionary decision that should be insulated from review by that jurisdictional bar? And ultimately, the 11th Circuit ruled in what to us at least is a relatively shocking decision, that it is discretionary, that even though the agency may be violating a procedural requirement in a binding regulation, that violation is not reviewable. That violation is encompassed by the sole and unreviewable discretion to make no risk decisions. And maybe it shouldn't have been surprising, because all of the circuits to have considered this question have ruled that there's no review. But that was the outcome there. And so unfortunately, we weren't able to break that losing streak on this Adam Walsh issue.
But those other circuits didn't consider the matter of choice argument, right? That was never actually presented to them. And this essentially completely allows USCIS to have the final decision on whether or not a human being can live with his or her spouse. And it cannot be reviewed in federal court, which is just exceptional. And you and I were at oral argument in Bordeaux, and I remember Judge Jordan up there asking the Department of Justice attorneys, to paraphrase, so you're saying that if the USCIS officer says, I'm going to deny every petition filed on a Tuesday, that's what I'm doing, and you filed on a Tuesday, so I'm denying. You're saying that we, the 11th Circuit, could not review that decision? And the DOJ attorney, to her credit, said, yeah. I mean, she tried to avoid it, but she said, yeah, you can't review it. That's what it means. And the 11th Circuit agreed. Judge Jordan, of course, was one of the three judges. Judge Jordan dissented in the initial panel decision and was one of the three judges who dissented on en banc. But that is an exceptional situation.
Right. I agree 100% with you, Kevin. Unfortunately, the majority of judges on the 11th didn't take our view of things, but there is always opportunities to keep fighting.
That's right. Well, we've been talking about jurisdiction and discretion and reviewability now for over an hour. Is there anything else you'd like to say before we go off?
I think the only other thing I would just encourage everyone to get involved with federal court litigation. I mean, it's the one way that you can, use your case to really make good law, sometimes bad law, but you can't make good law unless you try. And, there's lots of good resources out there to try to help people get started in bringing petitions for review, bringing district court cases. For everyone that's thinking about doing it, definitely we would encourage, at least I would encourage you to give it a try.
I'm going to include a lot of helpful links in the show notes of this episode so individuals can really get into federal court litigation. Thanks again, Eddie. I really appreciate it.
Good to talk to you. Thanks for having me on again, Kevin.
Bye, Eddie. My pleasure. So there you have it. I'm Kevin A. Gregg, a partner with the law firm Kurzban, Tetzeli, and Pratt, and this has been another episode of Immigration Review. Thank you for listening, and I hope you enjoyed it. If you did, please share it with a friend and rate and review us. Each review helps new listeners find the show. And of course, subscribe to Immigration Review wherever you get your podcasts. If you like what we do and want to become a patron of the show, please check out our Patreon page at www.patreon.com/Immigration Review, or click on the link in the show notes. And if you're interested in an official Immigration Review CLE certificate for 5 credit hours, email me at kgreg@kktplaw.com with your full name and the episode numbers for the 10 shows you've listened to. Also, feel free to email me with questions, comments, or anything at all. And follow the show on Instagram and Facebook at Immigration Review, and send us a tweet at ImReview. That's IMM Review. I'll be back next Monday for a brand new discussion. Until then, I'm Kevin A. Gregg, bringing you the Immigration Review.